Hello, I'm Locke Meredith. I'd like to invite you to join me on the next Legal Lines where I'm doing something a little different. I've got my two adult sons, both lawyers, and we're going to talk to you about the different kinds of damages you're entitled to when you're injured. But it differs based on whether you're injured in the course and scope of your employment or by somebody else who's negligent. So join us on the next Legal Lines with Collins and Mitch Meredith. I'm lawyer Locke Meredith. If you're battling an insurance company because of a wreck not your fault and they're not calling you back or being fair, whether you hire us at all, give us a call, 272-5555, or email Locke Meredith, Sean Fagan and Associates. You have nothing to lose.
Hi, I'm Sean Fagan of Locke Meredith, Sean Fagan and Associates. When insurance companies have been unfair, we've never been afraid to go to trial. Fighting hard to protect your rights, we never settle a case out of convenience. We only settle when it's right for you. Whether you hire us at all, give us a call.
Hi, I'm Mitchell Meredith. Injuries happen when you least expect them to, making your life more complicated. At Locke Meredith, Sean Fagan and Associates, we know this and we strive to help each of our clients during these times. Whether you hire us at all, give us a call at 272-5555.
I'm lawyer Collins Locke Meredith. Trust is important when hiring an injury law firm. At Locke Meredith, Sean Fagan Associates, thousands have trusted us and gotten the results they deserved. Visit us at LockeMeredith.com. Whether you hire us at all, give us a call, 272-5555.
Hello, welcome to Legal Lines. I'm Locke Meredith, and I'm very pleased to have on the show for the very first time two of my three sons, both of them lawyers, Collins Meredith, Mitchell Meredith. Gentlemen, thank you for doing the show.
Thanks for having us on.
Absolute, Pops.
All right, so, let's kind of dive into big picture stuff, right? We primarily handle injury law, and injury law is chopped up into what they call tort law, where you're injured by a negligent act. And it's got its own world of laws and regulations. You got workers' compensation, where you're injured in course and scope of employment. There's some other collateral categories like maritime or longshore harbor workers. We're not going to mess with that. That would be if you're working on or near water and you qualify as a seaman or a longshore harbor worker. Not going to talk about the maritime or 905B stuff. So, Collins, talk to me now about the difference between tort and workers' comp, but you focus on description of what you got to have for a tort, meaning an injury claim.
Sure. Yeah, all an injury claim is somebody has done something wrong to you, and because of their wrongdoing, there are damages that have resulted, and you can show the relationship between what they did wrong and the damages you sustained. So
and the wrong is called negligence in the legal jargon. They were negligent, they breached a duty that a reasonable person would have exercised in those circumstances.
Correct. And it can be any number of things. It can be property damage, it can be bodily injury, and the tort aspect comes with a lot of benefits to it as well.
Definitely can get higher recovery if you're able to meet all your burden of proof.
Exactly, and so if you can meet your burden of proof, you absolutely want to be in tort as opposed to workers' compensation.
Right. Tort injury law enables you, to get a greater recovery than you would if you were injured in the course and scope of your employment under workers' comp. Mitch, explain that.
Right, so the idea behind tort is you gain access to a little bit more damages. You've got special damages and then general damages. In workers' comp, you typically only gain access to special damages, and that's going to be in the form of indemnity benefits, that's going to be in the form of medical benefits and travel reimbursement. And in terms of the indemnity benefits, which is the wage component, you're actually potentially capped out. It would be 66 2/3% of your average weekly wage.
Let's dive into that a little bit. All right, so you're injured in course and scope of your employment. The one thing that benefits you if you're a dummy and chopped your own leg off, let's say with a chainsaw, and nobody else hurt you, you hurt yourself, guess what?
You got workers' compensation. As long as you can prove that you were injured in the course and scope of your employment and it arises out of the duties for which you were employed, you've got access to workers' compensation. And so,
Collins, explain the difference though. If I'm a dummy and I chop my own leg off, who am I going to sue?
Yeah, there's nobody to sue, which is why you want workers' compensation. And workers' compensation was a compromise that took place between employers and essentially
the victims.
The victims, and it was put in place in order to compensate people for that exact circumstance where I get hurt on the job, so somebody's got to help me pay for this. I don't have a means of doing it, but the problem is you're limited from recovering all the things you recover in tort, which if somebody else causes it,
You
you
get
want to be able to
100%
get
of
them.
what that loss is.
Which is pain and suffering, loss of enjoyment of life, loss of consortium, which is the relationship that I have with my spouse or other people, and how it's affected that, as well as all the specials that we've talked about that
Which
you
would
can
be the
recover
medical
workers' comp.
expenses, lost wages,
You
and all
got it.
that. The other compromise in workers' comp was that the government wants an economy to work. The way you got to have your economy work and have jobs and people make money in houses and everything is the businesses have to have a certain understanding of what their risk is if they actually engage in that activity. And that's why, Mitch, that as I recall, the benefits in workers' comp, even if it's the fault of your own frickin' employer or your co-employee, is limited, and it's not near what you would necessarily possibly get in tort. Explain.
100%. So the idea is, as you mentioned earlier, if you are injured by someone else, you can be fully compensated. And this, in workers' comp, if you are injured during the course and scope of your employment, you're going to be capped, even if someone else did that to you who is an employee or an employer. And as I was mentioning earlier, one of those limitations in your recovery is, say you were making great money. In today's day and age, what would end up happening is you would have a statutory cap on how much you can make off of that average weekly wage.
Because what's the maximum you can get right now per week?
I think right now it's $973 is the statutory cap. And then
It's like $650 wages a week.
a
would be
week.
the statutory
Okay.
cap.
All right, and so what that does is if you were taking home $2,000 a week, but you're in course and scope, all you getting is
Up
that's
to
six something.
up to 2/3, and you're limited to the 6 something. That's the cap on that. That's correct.
All right.
So
Now the beauty is, of course, if you did it to yourself, you're good. But are there not scenarios where you can have both a workers' comp claim and a tort/injury law claim, Collins?
there are, and so what you're going to be looking for is, did somebody else, not my employer, not my co-employee, hurt me? Okay. And so you can look to other contractors that are working on a job. So for instance, we get plant cases in. You got multiple companies that are working there. They're working for the plant themselves. Well, because they're not directly working for each other, if one of the other companies hurts an employee of the company working next to it, well, you can sue that company, okay? So that's a way to get out of workers' compensation. But because you were also hurt on the job, you still have the right to workers' compensation.
I'll give you an example. We've got a case that's kind of possibly going on right now where a gentleman exactly was at a plant and he was doing what he was told to do, which was open a valve on one of the pipelines, and it spewed him with very toxic chemicals, and he died relatively soon after that. And in that scenario, what you're looking at is going, okay, who screwed up? Who should have flagged that pipe off and marked it as being dangerous? And it was supposed to be a dead line. Wasn't supposed to be any pressure behind it or anything going through it. And whose fault is that? Is it, like you indicated, his employer or his co-employees' failure to tag it properly and make sure the damn thing wasn't live? Or was it some subcontractor that has nothing to do with who he's working for that screwed up, and they have their own insurance? Now, he has a claim to do what? He's got two claims, Mitch.
Yep. So essentially, what would end up happening is he would have access to workers' compensation if
Against his employer.
and he would have a tort suit against the person who was not part of his employment itself.
Exactly. The company or whoever he worked for, actually it would be multiple parties, probably the employee, the employer, and obviously their insurance companies and anyone else who could possibly be responsible. Now, let's talk about the relationship if you have both, where workers' comp pays, let's say they paid $200,000 to try and keep the plant worker alive and they couldn't. Can they get their money back from anybody?
Absolutely. I mean, they would be subrogated, would be the legal term of art, to be able to come in and get the money that they paid from the tortfeasor, the person who basically is liable under tort law
And Collins,
itself.
how they get that accomplished?
Yeah, they would go and you file 2 lawsuits, one workers' compensation, one you'd file in a regular old district court, or depending on what the circumstances are, tort court. And what would happen is they would lien that case.
They intervene in each other's case.
Lean the
All right,
case
we'll
to get the
continue
money
this
back.
on the next segment. This is Locke Meredith Legal Lines. My 2 attorney sons, Collins Meredith, Mitchell Meredith. We'll be right back, folks.
Hi, I'm Sean Fagan of Locke, Meredith, Sean Fagan and Associates. Open the phone book or look online. There are plenty of lawyers to choose from. And if you ask any of them, they'll agree that the vast majority of claims settle without ever having gone to trial. And I'll tell you, any lawyer can settle a claim. It's not hard to settle a claim, but it takes hard work to get a client what he or she deserves. At Locke, Meredith, Sean Fagan Associates, we have a proven record of working hard for our clients. Whether you hire us at all, give us a call.
Welcome back to Legal Lines. I'm Locke Meredith. I'm pleased to have on the show with me for the first time my two attorney sons, Collins Meredith, Mitchell Meredith. Let's kind of dive back in. All right, so let's talk about the tort damages, meaning the injury damages where somebody did something wrong, they were negligent, it caused you injuries, both physical, lost wage, whatever, all the other components of that, and you're going after them. Mitch, explain the general damages that you're entitled to, a fancy legal word or jargon word for what?
Right, so the general damages are going to encompass the damages that you can't have a document back it up with, so to speak. So
it's not a number
Right,
injury.
it's going to be pain and suffering, loss of consortium, which is the loss of love, society, and affection that someone lost because you were injured, essentially. And then you've got the special damages, which are going to be the damages that you can put a hard number on. That's going to be the lost wages, the medical expenses, travel expenses, things of that nature.
Collins, let's dive a little deeper into the tort injuries, the injury law damages that you can get.
Sure.
We were talking about the general damages as being pain and suffering, but it also includes a lot of other stuff. What does
Sure.
it include?
Well, pain and suffering is how have I been hurt? What's my physical pain and suffering? You got loss of enjoyment of life, which is how has this affected my ability to do all the things that I love to do? I love to horseback ride, I love to mountain bike, whatever it is. If I can't do those things anymore, I should be compensated for the fact that I can't do those things anymore.
That's right. Emotional distress too.
Absolutely.
Mental and emotional distress.
Absolutely. And loss of consortium, as my brother was describing, is the idea that, look, if I'm hurt and I can no longer have the same intimacy with you, whether you're my wife, you're my kids, whatever the case may be, there's a claim for that. And so, that absolutely has to be compensated. But you have to prove that the accident caused the injury or the damages that are preventing you from having these different elements. They're intangibles, right? So they're things you can't touch. And so it becomes very important for you as the plaintiff and us as the attorney to make sure that we are doing a good job of documenting just how it has affected you. Stoic clients oftentimes will try to minimize.
Meaning they just hold it in, they suck it up, and
they try
don't
not
like
to
to
show
moan and
it.
groan.
And it's important when you're bringing a claim that you are able to articulate and let other people know how you feel, because that's what that compensation's for.
And this is oftentimes, Mitch, the area where the jury has wide discretion. I mean, if they believe a person who lost their leg and now they maybe contemplated suicide and they got divorced from their wife, and explain how the jury analyzes, what's the evidence that's presented to the jury in those circumstances?
So everyone brings their own life, experiences to the actual kind of jury deliberation itself. And so oftentimes what we'll end up doing is trying to get them to put themselves into that particular situation. So the idea of how you would back that up is maybe by pulling in people who have personally witnessed that. It could be your wife, it could be your spouse, it could be your best friend, it could even be your doctor. If you're going in and talking to your doctor, Doc, this is really impacting me, because oftentimes people will get home, and as Collins mentioned, stoic, they keep it to themselves. People out in the world will present a certain face, but the moment they get home, they're around the people they know will love them unconditionally, and their guard drops. And then all of a sudden,
and they're no fun to be around.
Correct, and that typically
and
is someone who would be a great witness. They will be able to verbalize and articulate exactly the impact. I mean,
in fact, they become the victim's voice.
Correct, and that pulls to the loss of consortium, element. And it doesn't have to necessarily be, I can't play golf, I can't fish. It could be,
but it can be.
Absolutely, it could be, I can't change a light fixture anymore. I sit down for too long and I just start getting irritated. I get home and my kids come and jump in my arms and I pick them up and it just hurts. It wears on me.
Collins, let's shift gears a little bit.
Sure.
So we're talking about the general damages, which y'all discussed very well. Let's focus in on the special damages, which y'all have indicated previously is kind of the stuff you can put a number on pretty easily.
Sure.
How do you do it, and what are they?
Sure, and even for the generals, let's just make this clear. Oftentimes, your attorney will help you find experts, or you'll find experts, which are simply people in a certain field that can talk to a certain issue.
Psychiatrists, psychologists.
Psychologists, psychiatrists for mental issues. You have your physical docs for your physical issues.
And medications can be prescribed for depression and pain and all of those things. That's often evidence that you're going to have and must introduce into evidence so the jury sees. This is not just in their head, right? The professionals are saying it's serious to the point they need medication.
And oftentimes we're dealing with injuries where you have to have a doctor, because the doctor is the one who's able to say whether or not this is old, this is because of this accident, and you have to be able to establish that. And obviously, if the injury that you're suffering from that's causing your pain is 100% related to this accident, the value of your claim is greater than if it was a pre-existing injury that has been exacerbated.
That's where I was going. So Mitch, dive into that. So there's they call it pre-existing injury. If it's a pre-existing injury that is aggravated, you don't get as much. And then there's what's called a genuine causation injury. Explain the distinctions.
Right. So a pre-existing injury is when someone has an injury that they maybe knew about from a prior accident or something, but it had resolved and they weren't having any issues anymore, and then all of a sudden an accident occurs and boom, it flares back up. It went from being, asymptomatic to symptomatic.
Meaning no pain, no problems,
no pain,
no
and then
restrictions.
boom, all of a sudden it jumps back out.
Or some pain to more pain. It can be
Yeah,
that
so
as
Well, well, first we're talking about one that did, pre-existed, but you fully recovered.
Sure.
We're not manifesting any kind of real complaints or restrictions in any way, and then the accident happens and it's made back to where it was or worse. That's actually going to be worth more than one that was, you still were going on with the pain from a pre-existing problem and or injury, but hopefully it was getting a little better, but you still had the same problem. Then you had the accident, and now it's made worse. But you're not going to get as much money in that second scenario as you would the first, right?
Agreed. And the whole reason behind that is, in terms of the value of the general damages, that's left to the actual judge or jury depending on the value of the case or stipulations made. So that's the trier of fact, is the legal term of art.
Let's point out one other injury. It's called the Lejeune mental and emotional, but primarily emotional claim that another party who wasn't the injured party directly has.
Sure. Yeah, Lejeune claim is a claim where it's a bystander claim is what they call it. But
Right.
the idea is if you fall within a certain class and you witness injury to another person.
Basically, somebody with a close relationship with the
Very
individual.
Exactly.
Typically, it's a family
member.
And you either got to see it or you got to come upon the accident
Within a
soon
very
after.
short period of time,
And
right.
the idea is it's such a traumatic event, it's such a close relationship that there's a statutory right to recover for
And
that
again,
injury.
that oftentimes must be documented by psychological, psychiatric experts in medication. And it's got to be a really severe injury. You can try it. If it's, I sprained my ankle, I don't think that's going to fly. So typically that's going to be brought. I'm thinking of a horrible case where a beautiful little boy was run over by a car in front of his big brother.
Yeah.
That big brother will never get over that.
Yeah, sadly, when we're dealing with those claims, it's when people have been catastrophic injuries or losses. And,
It's horrible. So let's dive into the special damages a little bit more, and let's just kind of itemize. It's typically 4 or 5 things that you'll dive into. Go ahead and itemize it,
Sure,
Collins.
lost wages, loss of earning capacity. The difference is wages are, I can calculate I was making this much, now I'm not making this much. Loss of earning capacity.
I'll tell you what, let's continue this on the next segment. This is Locke Meredith with Legal Lines. Collins Meredith, Mitchell Meredith, my attorney sons, talking about injuries and injury law. We'll be right back.
Hi, I'm Mitchell Meredith. At Locke Meredith, Sean Fagan and Associates, we know each case and client are unique, and that no 2 cases are the same. But one thing remains constant, and that is our passion to help our clients. After an accident, we know your life has changed, which is why we passionately fight to make you and your family whole. Remember, whether you hire us at all, give us a call at 272-5555. We're here to serve you.
Welcome back to Legal Lines. I'm Locke Meredith. I'm pleased to have on the show for the first time my 2 adult attorney sons, Collins Meredith, Mitchell Meredith. Let's dive back in. We were talking about initially workers' comp versus tort/injury law and the differences. Bottom line, workers' comp, you can chop your own leg off and you get it, but you get very limited benefits. But you don't have to prove somebody else did something wrong. Tort, injury law, prove somebody did something wrong. you were injured by it, have damages, and prove causation that's related, you get paid a whole lot more over here in injury law than workers' comp. But you got to prove somebody did something wrong.
Correct.
So we were talking about the types of damages you can get over here in injury law, right? We talked about the general damages. Both of y'all discussed that component. We talked about the Lejeune claim for a bystander who has a close relationship with the individual who's hurt, and it affects them horribly from an emotional standpoint, psychological standpoint. Let's talk about the special damages that you get in injury law and how that compensation is different from workers' comp for the same component sometimes.
Sure. Well, we've discussed a little bit, but you have lost wages, which are, look, I can calculate I was making this much, now I'm making this much, or I'm not making any of it, and how long have I lost that? You do the math and you can figure out what that is. It doesn't take any expert to really come up with that.
Well, let's give an example. I'm working, I make 20 bucks an hour, I get hurt, now I'm making 10 bucks an hour. I got a claim for 10 bucks an hour for every hour I miss. Or I don't get any of the daggum money and I've got a much larger lost wage claim. It's easily proven. There's also another type of claim for loss of earnings. Explain
Right,
it.
that's loss of earning capacity, which is the idea of, look, because I've got these injuries, maybe I was going to get promotions, maybe I could have done other jobs, maybe I was qualified to do other jobs but wasn't doing it at this moment. But I'm not able to do those things. I'm not able to get that promotion. I'm not able to go that far anymore with what I'm making. And so you usually do have to have an expert for that.
Economic expert.
An economic
typically.
expert, and they'll come in and they'll tell you, and a voc rehab expert, and they'll come in
Right.
and they'll tell you, look, these are the jobs that are out there. This is what I think the money would have been worth now versus then, and they put that.
And it's
two
interesting,
together.
lost wage claim, like we said, if you've been working and at the time you're hurt, you can't work, it's easy to prove that. The loss of earning capacity claim, you actually don't even have to be working at the time you're injured if you can prove that, you're a guy that works half a year all the time because you're in construction or whatever it is. And so because of the injury is so severe, you've lost the ability to earn in the future what you would have earned, and you have to prove that with income tax returns and past employer information.
Which may have been your intent. And some of the other special damages we were talking about are the medicals, the hard medicals. So this is the surgery I got, this is how much it cost, this is what I can recover. That's past medicals, you've already done it. Then you've got future medicals, which is this is what the doctor is saying I'm going to need in the future, and what are the associated costs of those. And again, you got to have an expert, your doctor or somebody else testifying as to those amounts.
And again, an example would be, you fall, you injure a disc in your neck, they go in, do surgery. Clearly that's available, but the doctor also testifies it's pretty daggum certain that, or doesn't even require that level of proof, but within a probability of medical certainty that it's reasonable that you're going to need future disc surgery, and that's going to cost another $100,000. You're going to be laid up for 6 months, and so you've got further lost wage claim and all that. So that's kind of the past medicals, and then what may be available to you in future medicals. Also including a life care plan for folks who are severely injured, either paralyzed or have brain damage or a lot of other sad scenarios.
Correct, and we've seen that and dealt with that. Another component of special damages is property damage, which is, it could be as simple as my car got messed up, or there's other claims. A personal injury claim doesn't have to be limited to bodily injury, and we do a lot of that, but we also do a lot of property damage. Your house gets messed up or something else, and we could talk about that.
Mitch, talk to folks about the property damage.
So jumping into the property damage, typically what you end up running into is, can my vehicle be fixed? Someone hit it, it's broken, it needs to be fixed. If it can't be fixed, you run into the total loss scenario.
Which usually you get screwed on if you're the person who still owes
unless currently
$20,000.
Right, unless you're running into today's used car market.
Right.
But then you also have a rental coverage, or if for some reason you don't get a rental during that time period because there are some issues, okay, you'd have a loss of use claim. You weren't able to use it.
The vehicle.
The vehicle
You needed
itself,
to go to
or the
work.
property damage you lost. If you ended up having a tree fall on your home and you're unable to use your home, you would have a loss of use claim off of something like that. It'd potentially be maybe you having to stay up in a hotel room or renting another property, but that is an argument that could be made. And then the last one we normally see is what's called a diminished value or diminution in value. And the whole idea behind
Meaning
it,
the thing was depreciated in value.
and the easiest way to put it is, whenever someone goes and purchases a vehicle, one of the biggest questions that's asked is, was it involved in an accident? Why? Because you know you're going to be able to negotiate it down. So the idea is,
And there's a reason why, because they have more problems.
and it likely has not been put back together the same way. That could be that they put aftermarket parts on rather than the OEM parts. Could be that the paint does not match the same degree. Then also you're going to have an accident on that vehicle's title history for the rest of the vehicle's life.
Yeah, I mean, it's why they have Carfax and all the other little services that you can use to figure out how much you're willing to pay for a car, and you get the previous owner's history and accident history. Talk to folks about kind of the penalties and deadline statutes that exist out there. Give kind of the basic structure of it, and then we'll have Collins talk about some of the components of the penalties and fees.
So there are really two main kind of, we'll say, penalties area or bad faith areas that you typically end up running into. And it depends on whether or not it's your insurance company or someone else's insurance
So
company.
for example, if I'm in a car wreck and I've got insurance on my car and the other guy's at fault, he would be considered a third-party insurer. I have a direct contractual relationship with my insurance company. There's a difference in the responsibilities that those two insurers have towards me.
Correct, because your insurance company is supposed to act in your best interest, right? So the idea would be is, say I'm involved in an accident. My vehicle ends up sustaining damage. I end up deciding to use my own insurance company to fix it. I end up sending everything that they need to determine this vehicle needs to be fixed, or typically what we see is this vehicle is totaled out. Okay?
Which is called sufficient
proof of loss. And so what ends up happening is once you give that to them, they have a certain time period, which is 30 days, to unconditionally give you the undisputed money. Short way of putting it is they got to hand you a check, no strings attached, for the amount of the vehicle less the salvage value.
Now, also one condition that often occurs is when you got a mortgage on the car, right, Collins?
Right,
Now that
yeah.
check may not go straight.
Yeah, lien.
Yeah, absolutely. And so they'll put the mortgage holder's name on the check, or they may send it to the mortgage holder. And usually what they'll do is they'll call, find out what the difference is, send a check to the mortgage holder, and send you the difference.
So explain kind of the aspect of the penalties and fees. What can they do wrong or not do
Sure.
that entitles you to more money than just what they owe you for the loss of your vehicle?
Sure. Well, first I'm going to take it as a first party claim, which is, look, I have a contract, I paid this contract, I paid premiums for this type of coverage, and I'm now wanting to use that coverage. Okay, so in the example of an auto accident, car gets in a wreck, I want to use my insurance, comprehensive or collision, to fix the car. Okay, I give them the proof of loss to fix it. They don't get me a check within 30 days, even though they've had the proof of loss. Then we get access to 50% of whatever is ultimately determined to be owed.
So if they owe 10 grand, they might have to pay another 5 grand.
So 15,000 total plus attorney's fees.
Which could be a third to 40% of that amount, depending on what the contract calls. Gentlemen, it's been enjoyable.
It has.
I'm glad to have you on. This is Locke Meredith, Legal Lines. My 2 adult sons, Collins Meredith, Mitchell Meredith, both lawyers. Thank you for being with us today, guys.